grounds upon which you can come to court and get a stay even where the validity of the order is not at issue. In terms of the test that's been adopted for the grant of a stay or an injunction, the federal court in a case called Toth recognized that they should apply the test that was adopted by the Supreme Court of Canada in Metropolitan Stores. I've got the case cites in my papers, so you don't need to worry about the cites. The Metropolitan Stores, the Supreme Court of Canada had said serious issue. You had to show there was a serious issue before the court, that the person might suffer irreparable harm, and that the balance of convenience favored the grant of injunctive relief. In Toth, in the Supreme Court of Canada, Mr. Justice Bates said serious issue was satisfactory for a constitutional question, rather than the prima facie case, which is a higher standard. In Toth, which did not raise constitutional issues, the Federal Court of Appeal adopted the same test. So for immigration and refugee matters, you do not have to meet a prima facie case. Some of the judges do appear to be still applying a prima facie case test, although I think if they're called on it, I mean, if you have Toth with you, they will recognize that the only test is a serious issue test. It's important if you're doing stays that I think that the essential cases you have to have are Toth and Metropolitan Stores. And if you're doing a back-end agency, you should at least have the Hamilton decision from Madam Justice Reed, where she talks about the jurisdiction of the court. Anyways, in terms of serious issue, I just went through all of the unreported decisions that we have on the federal court, and we keep most of them. One of the things the Supreme Court of Canada says in Metropolitan Stores is that it's not up to the judge on a preliminary application of this nature to resolve conflicts in the evidence. I think that that principle applied in Metropolitan Stores also applies for leave applications. The federal court on a daily basis gets involved in conflicts on the evidence on preliminary matters and makes judgments. You should have Metropolitan Stores to be able to quote back to a judge that they are not supposed to be deciding the issues where there's a conflict in the evidence. The other point that the Supreme Court of Canada raises in Metropolitan Stores is that it would only be in a rare and exceptional case, they're talking about charter issues, that the court should resolve a legal question on a preliminary matter. The federal court on a daily basis resolves complex legal issues, including charter ones and non-charter ones, on applications for stays and on applications for leave, although they don't give reasons. Again, Metropolitan Stores is essential because if a judge goes on about conflicts in the evidence or about whether or not the issues can be determined by the court at the time that the stay is being considered, you should actually quote it right back to them. They're bound by the Supreme Court of Canada. One of the problems is I don't think that the federal court judges have been made aware very often of the principles that have been developed in Metropolitan Stores, and even where they are aware of it, there are times when they have completely misquoted it in their reasons. One example is Brar, which the court uses all the time. It's reasoning of Mr. Justice Mackay, where he says that you can only give a stay in an exceptional case. Mr. Justice Bates in Metropolitan Stores says that is the wrong test. It is not an exceptional test, and it's explicit in the reasoning of the Supreme Court of Canada. So if you have a judge, and many of the judges in the trial division use this standard, exceptional case standard, take Metropolitan Stores and throw it back at them because they haven't read the case in terms of the kind of law that they're deciding in the federal court, both levels, I think. Another point in Metropolitan Stores is that the evidence is it is anticipated that you will not have a complete record before the court. You're coming before the court on an emergency motion. The evidence will be sketchy. The court is not to assume that that is your whole case, and they are not to hold that against you. The court holds it against people all the time. Having said that, however, I think you have a duty in preparing your applications to meet the three issues. You have to be able to show in your evidence that there is at least some serious issue. You have to be able to show that your client will be harmed in some way if the stay is not granted. The balance of convenience, it's hard to show, but I mean in terms of the public interest in your client's situation, although I think if irreparable harm is an important and weighty issue, it carries the balance of convenience issue itself, or it should. The third point, which is important and which again is ignored by the federal court on a daily basis, is that there is no presumption of constitutional validity. In Metropolitan Stores, the Supreme Court of Canada says there's no presumption of constitutional validity. Mr. Justice Bates goes on for pages saying the Charter is an innovative document, that you cannot presume that the legislature has passed a constitutional law. That's very important. The federal court, if you look at all these reasons, they presume that the law is valid and that it's presumed to be valid until the court determines otherwise. That has been explicitly rejected by the Supreme Court of Canada in Metropolitan Stores. I'm telling you all these things because I think you've got to go to court prepared. I think it's really important that people start arguing stay cases in using Metropolitan Stores in terms of what the court has said. Metropolitan Stores in its own way is a very restrictive decision, but there is a lot in it that should be used. And when you figure that the federal court judges are bound by the Supreme Court of Canada reasoning, it's really important to try and dispel some of the assumptions that the federal court judges have automatically applied. This, I mean, in terms of the serious issue and the presumption of constitutional validity, it is out the door, but the federal court doesn't know that. So I think it's important to, you know, take those passages, highlight them, carry them with you so you can deal with those issues as they come up. I think one good case for the application, not on any other point, but on this point, serious issue, is Mr. Justice Mackay's reasons in Duganich on the serious issue part. Forget the rest of his decision, but on the serious issue part, he points out properly, I think, in light of the Metropolitan Stores test, that it is not the court's role to decide the issues now, and that he assumes as long as there's anything on the record that may be serious, that's enough. So his test is, I think, a proper one. In terms of irreparable harm, the Supreme Court of Canada and in Toth as well, the courts have indicated that it's harm that's not compensable in damages. What appears to be happening in terms of the sort of practice of the federal court, substantive practice, is that if the person is facing removal or imminent removal, you may get a stay. It doesn't mean you will get a stay, but you may get a stay because there is some suggestion if the person will face some difficulty or refugee-like harm going back to their country that a stay can be granted. One case that's important is Mohammed in the Federal Court of Appeal. Mr. Justice Hugeson recognizes, it's reported, recognizes that there may be no harm in continuing with an inquiry, but if you reach a point where a removal order may be issued, that harm may occur at that point in time because removal would remove the person, could remove the person from the jurisdiction. Halting or stopping an inquiry from concluding as opposed to continuing was also recognized by Mr. Justice Muldoon in the Yap case. So it would be very unlikely that you would get the court to stop an inquiry from proceeding. But if you're at that point in the inquiry where the person is likely to be issued a removal order, they can enjoin against issuing the order, so the inquiry does not conclude. That's really important for backlog claimants, because under the current interpretation of backlog regulations, once the order is issued, they lose the right to work. So if you can stop the inquiry, if you're seeking leave from a credible basis refusal, the inquiry hasn't concluded, you can go to the court and seek a stay to stop the order from being issued, because what will happen is your client will not be able to work any longer, their kids won't be able to go to school any longer, and that clearly could come within irreparable harm. In terms of the kind of harm that the persons face, the court seems to be all across the board. There's Mr. Justice Mackay's decision in Kerr, where he says that there's no irreparable harm to a permanent resident being removed who's been here since 1975, even though he's got an addiction problem, he's dependent on his family in Canada, he has no family in Guyana, he has employment in Canada, he's got no employment in Guyana. I mean, it's a classic case for irreparable harm, and irreparable harm is found not to exist. However, in other cases, the court has recognized, like in Toth, that loss of employment, dependency of others on the person, in relation to employment, can amount to irreparable harm. Mr. Justice Mackay in Duganich recognized that denial of education to children or loss of right to go to school could amount to irreparable harm. So those kinds of cases can establish a broader standard. There are, however, a lot of decisions in the federal court, like Mr. Justice Teitelbaum and Said says, you know, if you'd shown me there was a risk to life, maybe I would have given a stay, but you didn't. So you can't have a stay. I mean, irreparable harm has never been said by any court in the country to be a refugee test. What the federal court is attempting to do, I think, in some of these cases, is to equate it with the refugee definition. Certainly, Mr. Justice Joel, Mr. Justice Mr. Justice Mackay on occasion, and Mr. Justice Teitelbaum, and also the Associate Chief Justice, even in some cases, seem to equate it with refugee-like harm. There are cases, and I think one of the other things that's important is to look at some of the other areas of law. Like if you look at Metropolitan Stores, they cite Rio Hotel. The guy was worried about losing his liquor license. I mean, he could still run his hotel, and he got a stay. I mean, a loss of a liquor license when you can still run your business doesn't equate to removal of someone who's been in Canada since 1975 with no family to go to. So I think you should start comparing not just immigration stays, which are very depressing, but look to other areas of law where it's big companies fighting each other and look at what they go on in terms of giving stays. I mean, and then use that by comparison. I mean, loss of connection with your family has got to be more important than not being able to serve liquor in a bar, I think. Anyway, serving liquor in a bar, if the person won, it could be compensable in damages. Whereas loss of connection with the family might not be. The purpose of a stay, which is also recognized in Metropolitan Stores, and I think should be argued at the outset of these motions, is to maintain the status quo. It's no more than that. If removal would result in a complete change of the status quo, then arguably the person should have the advantage in terms of being able to get the stay. One of the issues where the court will recognize that a stay should be granted is where its jurisdiction would become nugatory. It would be moot if the stay weren't granted. A good example of that, again without reasons, is Blackwood. Mr. Justice Marceau gave a stay to stop the Refugee Division from hearing his case because if it did hear it, it would hear it in public. The issue before the Court of Appeal was whether it should be public or in camera. Obviously, if they go ahead with a hearing in public, you've got no appeal before the federal court because it will have already been held in public. And the person wants it being held in camera. Those kinds of issues are important issues. In Venkov, we argued that the application would be rendered nugatory. In that case, the people were trying to process through a Canadian consulate in the United States. And the Immigration Commission wouldn't give them back their passports so they could go to the United States. To process, they were under order and they wanted them to go back to Bulgaria. Well, if they went back to Bulgaria, there was some suggestion that they might not be able to come back, and they certainly couldn't process through Detroit. So we argued that the application at the end of the day, if they were sent back to Bulgaria, given that that was the issue before the court as to whether or not they should be sent back to Bulgaria, that would make the whole issue moot by sending them back in the first place. And the court accepted that in Venkov. In terms of charter issues, the court has recognized in a number of cases that stays can be given. Devinder Singh and McCallie, Mr. Justice Muldoon's reasons, where the adjudicator wouldn't recognize that he had jurisdiction to deal with constitutional issues. They are good reasons, they're long reasons, but they're good reasons in the sense that they recognize that it is important to have the remedy before the court in relation to the constitutional challenge, to have it dealt with by the court, rather than to lose your right to raise it until after the fact. However, that's the only case where the courts recognize that Section 24 of the Charter has any meaning in the immigration context. In every other case where the issues have gone to the court around the right to go to a court of competent jurisdiction on a charter issue, the court has virtually ignored the fact that 24 of the Charter does guarantee that right. The way it stands now, that right is guaranteed to everybody but immigrants and refugees. Section 24 of the Charter is meaningless within the context of immigration. And I mean, you can tell I'm very negative about this, eh? No. But I mean, it's really depressing. It's very depressing to read other areas of law and to see that the courts give people proper consideration and apply proper principles of law. And then to get to immigration and refugees and to find none of it means anything. I mean, they don't even read Metropolitan Stores properly in terms of how they're, like you just read Brar, Mr. Justice Mackay's reasons at the end of Brar, and then read Metropolitan Stores, and you wouldn't know that the Metropolitan Stores that Mr. Justice Mackay is relying on is the same Metropolitan Stores that Mr. Justice Bates wrote. It's really bad. These judges are being paid a lot of money to be to be applying the law. The least we can expect from the least we can expect from them is that they will apply the law. You know, that they'll spend some time and read the cases.
Contact on mic 3 here. One. That.
The only thing I can say is that Barbara's complaining about the judges not reading the law. Please remember that it's your obligation as counsel to present the law to the judge. Okay?
Yes, but if they have Metropolitan Stores in front of them, they're going to rely on it like Mr. Justice Mackay did. The least he can do is read it himself. Anyways, I'm going to just cover the last point, balance of convenience. Again, I think you should go to Metropolitan Stores. Metropolitan Stores, they say you have to balance the public interest against the individual rights affected, the person's rights. When you look at what the court was looking at in terms of balancing the public interest, there are 4 points that the court thought was important. The magnitude of the impact of giving the stay or injunction. And they were talking about cases where the whole province was going to lose its tax base. Paralyzing or disruptive impact on the general order. Again, they were talking about ones that had broad impact in terms of suspension of operations within the province. Third was public confusion, and they used that in Morgentaler, where the public wouldn't know whether it was illegal or not illegal to give an abortion outside of a hospital and could result in confusion. And fourth, the suspension of police enforcement. Well, we all know removal from Canada is not a punishment. So immigration does not come in the context of police enforcement. So you can forget that last one. What's happened in the federal court is that some judges, and they have been quite clear about it, have indicated that the public interest is binding. The public interest, if the statutory authority to carry out a public duty is stayed, the public suffers irreparable harm. And for some judges, that's as far as they go. The Supreme Court doesn't say that the public interest is irreparably harmed if a stay is given. They say you have to balance the public interest against the factors that are before the court on consideration in relation to the granting of a stay. And what they're talking about all the way through their decision is the broad impact. They make a distinction between two kinds of cases. When you go to court for an exemptive stay or injunctive relief, what you're seeking is an exemption from the operation of law that affects an individual person, is based on the individual facts of the case. There need be nothing exceptional in that kind of situation in order to get a stay. And the public interest, presumably the way the court has looked at it, is not an overriding consideration. The second kind of stay application or injunction application is called a suspension injunction, where the giving of the stay suspends the operation of the law effectively for everybody involved. And even on that level, the court says the exceptional standard test is not necessarily the case unless you can show that there's a lot of people affected by the outcome of the decision. So for instance, if you take Brar, which was the Security Intelligence Review Committee, where Mr. Justice Mackay says the public interest is of paramount importance and it's going to be irreparable if we give a stay, how many people come before the Security Intelligence Review Committee? Probably about 10 a year. There's not a big impact in terms of a lot of people affected by a suspensive injunction. You compare Brar, where the person's individual life, liberty, and security of person was at stake, with York, where you had about 20 companies coming to court and saying, look, the Thompson newspapers is in the Supreme Court of Canada arguing an issue about the constitutionality of Section 17 of the Combines Investigations Act. We want to stay an injunction to stop the Combines investigation people from investigating us while that case is before the court. The court gave a suspensive injunction. It stopped the operations of the Combines Investigation Act until the Supreme Court dealt with the Thompson newspapers case. Thompson newspapers lost at the end of the day in the Supreme Court. But in any event, everything was suspended under the Combines Investigation Act. The court noted there was only a few companies involved. Like, you compared that kind of treatment with Brar, and they don't match. You're in two different courts, one which deals with companies in a different way than one which deals with people, I think. But anyways, I think you should go back. I also think you should use York, because it's a very important case in terms of recognizing that it can be very minimal. when a stay can be given and suspensive stays can be given. The last point I wanted to make was that you should know, if the minister decides not to remove your client, I mean, sometimes we sort of figure we'd rather have them attempt to remove and let us go get a stay so the person can work. Section 19(4)K of the immigration regulations says that where a deportation order can't be executed, the person can apply for a work authorization if they would otherwise have to be on public assistance. In the Stewart case, Madam Justice Reed says that she can't see the difference between the minister voluntarily deferring removal and a case where an order of the court has been given. So what she says is that, and I'll read it, it would be strange indeed if an order of the court requiring that a deportation order not be executed could bring the plaintiff within the purview of subparagraph 19K4, but an undertaking given by the minister for the purpose of forestalling an application to the court for such an order would not. It may very well be that the plaintiff could bring an application for mandamus to compel them to give a work authorization. I don't know that the Stewart case went anywhere. I didn't find any cases where they finally decided the issue. But I think it's arguable if you have clients hanging around, the minister's not removing them, to send them in and apply for a work authorization and cite the Stewart case. Because they're not being removed because the minister's not prepared to remove them. Therefore, in that situation, the deportation order cannot be executed and they should be allowed to work. The other cases where they should be able to continue work permits is where they can't be removed because they can't get a travel document. Often people hang around for like a year or so because there's no travel document. In those cases, they can. In fact, they have been giving work permits in those instances. So you should know, even if you don't go to court for a stay, your client should be able to work through this time period.
Liz has asked for the last word, and I told her it has to be only a word because we still have to hear from Mark. I know some of you have to leave, and from Rod, but we'll push forward.
I will be very brief. The only thing I wanted to add to what Barbara has said, and is to stress what Barbara has said, is that probably nothing you do for your client will be more important than arguing his stay of removal successfully, because if he's gone, he's gone. And nowhere is it more clear to Justice Council as to whether or not Immigration Council know what they're doing as at a stay, because the law, although it may not be defined, there's a body of law there, and it's with respect to stays, and we know if you know it or not. And I think the judges know it also. So it is worth taking the time to do a stay well. Now, having said that, I want to say something on behalf of the federal court, not in terms of their jurisprudence, but in terms of their user-friendliness. The court is always available, and until now, the court has always been very willing to hear stays on short notice, and will do so. They'll try, in my opinion, make every effort to ensure that your client is given a hearing before they leave. We are noticing an increased irritation on the part of the court on stays brought on very short notice. That is, your client is aware for 3 weeks that he's going to be removed on June 15th, and you're appearing in court on June 12th at 4 o'clock saying, please hear my stay. My client's leaving Monday morning, and the court is getting increasingly angry about this. So if you're aware of removal, please get into the court early. And I'd like to read you the reasons for decision of Mr. Justice Strayer issued on Wednesday with respect to this very issue. It said, he dismissed the stay, and he dismissed the stay on the basis of no irreparable harm. The case name is Claudia Elizabeth Vaccarino versus MEI, court file number 92T778. But he said, I indicated to counsel, however, that apart from that reason, I would have been disposed also to dismiss the application for delay. As the Supreme Court of Canada said in Metropolitan Stores, the criteria for a stay are the same as for an interlocutory injunction. Just as an interlocutory injunction can be refused on the ground of delay on the part of the applicant in seeking an injunction, so, in my view, can a stay be refused on this ground. There is no support in the material filed on this motion for a stay to justify the applicant taking no steps to challenge or delay the execution of the departure notice until 6 days preceding her scheduled departure, nor for not making any application to the court until 2 days before that departure. It is true and regrettable that the adjudicator did not advise her of her right to seek review of the departure notice. That may be a factor in consideration of her application for leave at this late date, but it is no justification for her taking no steps whatever until the last moment to obtain legal advice on any possible ways to delay execution of the departure notice. In my view, this is the kind of situation where, on the face of the record, the court would be justified in refusing the extraordinary procedure of an urgent hearing. Among other reasons, such last-minute applications leave counsel for the respondent little or no time to receive instructions on the fact of the situation, and this must be of concern to the court in considering whether to issue the extraordinary remedy of a stay. Applicants and their counsel should be aware that waiting till the last minute to make these applications must therefore detract from, not enhance, their likelihood of success. And I would add to that that yesterday, Madam Justice Reed made an order on a stay application saying, request to have the motion set down on an emergency basis is denied. The deportation order issued February 27, 1992. Delay in seeking a stay of that order has been too long.
Yeah, but
No, but you see, what's
that's
the
the
problem?
catch-22, because on the other
Yeah.
side, the court won't, if you apply to the court for a stay, they won't give you a hearing on a stay until you find out the date of removal. I mean, this is, I mean, you know.
I appreciate that that is a catch-22, but I am aware that unless clients are in detention, in many cases they'll have nearly 2 weeks before they know that they're going to be removed.
Yeah.
I'm not trying to take a position on this. I'm advising you of the irritation level of the court because I want you to be aware that it may affect decisions affecting your client.
Yeah, but the court's irritation level, I mean, I don't buy that. They're removing people, and we as lawyers, granted, you shouldn't delay. I mean, if you know 2 weeks ahead of time, get your act together and get the application in. But, you know, it's not our fault they're removing people. As lawyers, we have to effectively represent our clients. We have to bring applications. I appeared before Mr. Justice Teitelbaum where he was complaining that our firm was bringing too many stay applications. I mean, well, what does he expect? I mean, if I'm acting for people and I'm trying to stop their removal, I don't think I deserve the irritation of the court because I'm trying to represent my client. And no, really, they do. They get upset all the time now because they think they're being inundated with stay applications. Well, the minister has upped its removals, so they're going to get more inundated, and I don't think they have a right to be upset about it.
Okay, stop. We're not having any more fights on it. Okay, we're moving. I want to thank you both. I mean, and the boxing gloves are outside, and we'll. No, yes. Okay.
Wait. No, but you see, we've always assumed, maybe this is wrong, but we've always assumed if we apply for a legal aid certificate, or a client does, to go to court on leave, we assume that the stay is part of the certificate, that it's a necessary step in representing the client before the court. I've never sought authorization to get a stay.
Sometimes people want to change lawyers, and I find lately I'm getting a lot of phone calls and notes asking for stay applications and things like that.
On their own, without the regular certificate?
People who are the celebrities in the Metro West are calling in and they say they want a lawyer to bring a stay. So,
Okay.
yeah, I think there's something wrong. I think it's wrong. My understanding is that you need to have an authorization to do it.
No, if you've got authorization to act in court, the stay's part of it.
You'll have to check that out with some of the others.
Is that right, Ruth? Okay, Barb, you can stay up on the podium if you want. I'm going to bring up the other guests. I don't know. Are you? Okay. This is a two-part. We have a special celebrity guest, unannounced, unprogrammed. No, that's you. That's you. I'm just teasing. No, Rod is here, and he's going to talk for a few minutes about legal accounts, which I'm sure you all want to know because he's going to tell us all the reasons why we don't get paid and all the things we do wrong. And we thought it was important because there's been a whole bunch of problems. And then after that, immediately, we are going to go and hear from both of you, or just both? Okay, this is Mark Leach and Laurie Newton, and they both are with the Attorney General. Yes, both with the Attorney General. Both with the Attorney Generals, and they are the people who are going to be coordinating this new thing that we all read about in the Globe and Mail, because the Toronto Star is on strike, right? So about the immigration clinics. So in any event, we'll hear from Rod first, and then we'll move on. And then, since everyone is beginning to wander out, I probably won't have anything else to say when this is all over. So I'd like to, before you all leave, thank you for being so attentive on such a beautiful Friday, and thank the technician over there for listening to us and putting up with us all day, and thank the people upstairs who had to get stuck upstairs, and thank Ruth Lawson for helping organize this, and all the people at the Law Society, none of whom are here now, for organizing this, and all of you for being here. Thank you. Pardon me? Yeah, Barbara has this paper on the stay that she's written that will be sent. She's editing, and I don't know. Is there someone from the Law Society here still who can tell us how that's going to happen? Okay, so then they will mail. The Law Society will mail it in a collect. No, I'm just. Okay, so here's Rod Strain. He's from the Legal Accounts Department and of the Ontario Legal Aid Plan, and he has a whole bunch of things to tell us about why we don't get paid enough. He's going to announce an increase in the tariff? No.
No, unfortunately not. Okay, I'm going to be as brief as possible, but hopefully in 10 minutes or less I'll alleviate some of your concerns with getting your accounts back, and hopefully eliminate all the accounts that come back with red circles and blue pens written all over them. There's three major concerns, and from my experience with the accounts, there's three basic reasons why accounts are being sent back. And it's not the size of the accounts, it's not that they're not fitting within the tariff. We understand that the tariff is very restrictive, too restrictive in some areas of immigration law. The three areas where accounts are being cut back is, one is authorizations to proceed, which have to go through the area office, and the Legal Accounts Department has no discretion to pay accounts that aren't authorized previously. The second area is that we're not getting enough information in requests for discretion or within the body of your account to exactly know at what stage of the proceeding or what exactly is going on with the certificate. And lastly, which I'll touch on briefly at the end, is relating to disbursements. First of all, the one major concern that we have is in one certificate that authorizes a notice of motion in client's name only with an opinion on the merits of proceeding further. That certificate is only intended to preserve your client's right to appeal. It's not intended to cover any supporting documentation which is submitted with a leave application. We encourage you to get your opinion letters into the area offices as quickly as possible and try to direct them to the appropriate people. Sandra Birnbaum handed me this earlier, and I just want to remind you that we now have 4 different numbers for the Toronto area, 46 and 51. Certificates starting with 46 and 51 should be either sent by letter or preferably faxed if there's a rush on them to the area office at 70 Centre Avenue. And there are now 3 more satellite offices with their own area committees in Scarborough, Etobicoke, and North York, starting with 52, 53, and 54 respectively. So if you get those there, area committees are meeting as often as possible and dealing with 20 to 25 of these a night. In order to get authorizations to proceed. If you submit your accounts with preparation of affidavits or memoranda of fact and law, they will not be paid on these certificates. You will get a new certificate authorizing all leave and appeal procedures. The second part is information that you're giving to the Legal Accounts Department in the way of discretion letters. The tariff is extremely restrictive in respect to leave to appeal, and Legal Accounts understands that. The maximum is 10 hours, which is very rarely sufficient in order to pay these accounts. We don't need a lot of information to look at discretion in paying accounts on leaves between 10 and 20 hours of preparation time. Anything further, we need sufficient information to make a decision on a discretionary increase, the complexities of the case, etc. It's not sufficient to simply state that the case was complex, the client did not speak English, etc. We had to deal with an interpreter. That doesn't set it aside from the normal immigration account that we see. What we're looking for in discretion is, why is this particular file involve more hours than the one we normally see? The other, and I think perhaps most important aspect, is disbursements. A lot of accounts are going back with interpreters' accounts being circled, travel time disallowed, time over 10 hours being disallowed. There are constraints, budget constraints that may be coming down, and we're looking towards ways in reducing accounts. And I think the easiest way and the most beneficial way for council is to reduce it in the area of unnecessary disbursements. Travel time for interpreters was initially put in to assist council to obtain interpreters in languages that may not be available in their general area. It wasn't intended to be for every single interpreter account. We encourage council to use interpreters that are convenient to their office, use the same interpreter so they become familiar and their bills are proper and their bills are easily payable by legal aid. More often than not, we get 3, 4, 5 hours of travel time, no indication of the number of kilometers traveled, and we cannot pay travel time if it's under 25 kilometers in one direction. And that's where accounts are being sent back, and that's where it's becoming a great aggravation to council, because they've paid the interpreter, or the interpreter's after you for money because you have said you will pay him. Well, all we want to do is ensure that that's a proper and reasonable disbursement. Council does sign all accounts and say that the disbursements are proper. You have retained the interpreter, you're responsible for paying them, and you will get reimbursed what legal aid allows, what the legal aid rates allow. You may have to pay the interpreter more than you're getting to us if you lose contact with him and can't find out how far he traveled or where his office was. Other areas of concern with respect to disbursements are translation of documents. We ask you to seek prior authorization for all documents and all matters that have to be translated. Our standard rate is 20 cents per word, and that was intended to be a notarized translation that's going to be admitted into evidence. What we do encourage counsel to keep costs to a minimum is to have an interpreter review such documents, so when they come to us approaching up and asking for authorization, we all have a good idea of what's in the documents and whether they're going to be admitted into evidence, or whether they're a duplicate of something else that may be translated elsewhere or available at various centers and documentation centers. The other thing that's becoming a concern, I haven't really seen enough of them to know how widespread it is the service of documents. There's nothing really in the tariff that defines how much legal aid allows for the service of documents. At one time, we were being rather sticky in the Toronto area, allowing $25 for service of a document and $10 for filing fees. It's become an issue now that the federal court rules have changed, and all we're asking is the assistance of counsel in ensuring that these disbursements are reasonable. We don't, I've been seeing accounts for $75 or $85 to serve the notice of motion for leave. Now, if that's one document for one client, that may or may not be reasonable. However, if you're doing more than one document, serving more than one notice of appeal at the same time, we encourage you to be reasonable and to try and keep costs to a minimum for the plan. We have no way of checking. We have no way of matching up files, and it's very difficult for us, but there does appear to be some concern. Excuse me. Again, with respect to disbursements, I want to stress that it's out of our hands. Council hires the people that are billing disbursements, i.e. interpreters and service companies. And we just encourage you to keep in mind the cost to the plan. Interpreters are a great cost in these matters. And ensure that the bills are reasonable. If you can find an interpreter that's close to your office and reliable, please attempt to do so. Please attempt to schedule longer interviews with interpreters, thereby reducing travel if you have to bring them in from distances that are greater than 25 kilometers one way. And please try to take carriage of the file. Don't let the interpreters or consultants or other matters take carriage of your files. And I've seen interpreters' invoices that are 3 and 4 weeks before the initial interview with a solicitor. In those cases, it becomes fairly obvious who's in charge of the file and who's billing who. And we encourage you that we only are intending to pay interpreters that have been retained by you for specific services. We will pay law clerks as well, and we encourage you to pay clerks to engage law clerks wherever necessary, and try to keep the cost of the certificate program down to a minimum, especially with respect to disbursements. As far as fees are concerned, we're trying to work with the tariff that we have. It does provide some constraints. But as I say, if you provide us enough information, and my general, I would suggest, if in doubt, provide us some details in a letter for discretion. Don't worry about counting up your prep maxes and your attendance maxes, etc. If you feel you're anywhere near, or if you're preparing for leave, ask for discretion. Chances are you may need it, and if not, it doesn't hurt to keep the legal accounts department informed as to what's going on with the file. So if it's needed, a legal accounts officer can take a look at the file and pay your account initially without having to send accounts back and have them reviewed at some point, because it causes everybody aggravation. And if we can do it all in the beginning, it saves a lot of time and a lot of trouble for you. That's it, unless there's any questions briefly.
One or two questions? One question. One question. Go ahead. Okay, you got it. Yep. No, there's 5 people, but you got the one. You get it. Go ahead.
I had a question about the interpreter travel fund, and I had written to the accounts department requesting some clarification on the 25 kilometers, because there seemed to be the interpreter saying one thing and the accounts department saying another. The letter I got in response I found not very helpful, because basically the letter said, yes, we're having a hard time applying this policy. And I'm wondering, is there any better guidelines?
Yes, 25 kilometers one way means from their place of business to your office, be it their...
And who calculates it, and how are you doing it?
Okay, we cannot calculate it. We cannot take addresses from all over Ontario and decide it's 25 kilometers from somebody's office. You sign the accounts and you say that the disbursements that were billed were proper and were reasonable. And how you do it, I mean, you have to satisfy yourself that it is 25 kilometers, and in turn satisfy us that it is 25 kilometers.
No more no questions, but the point is, I mean, I've had that fight with interpreters. So the interpreter then says to me, well, I'm going to move, my address to Newmarket, and then for sure I'll be 25 kilometers. Well, then I think your response in that situation is to get a new interpreter, because, I mean, anyway, no more questions, because everyone, it's really a nice afternoon, and we want to have this last person tell us everything we want to know about these new clinics that are coming up. And, well, first of all, thank you, Rod. So, the floor is yours. And I'm getting away because I want to be don't want to get hit by any
out of range.
potatoes. Turn the mic on. I'm just teasing.
Okay, I'm Mark Leach. I'm with the Ministry of the Attorney General. I'm the project director of the reallocation review process, and I think we'll just do a quick rundown of what's involved in reallocation, what it has been, and where it's going generally, and then I'll let Laurie Newton make a couple of comments about the status of refugee pilot projects, which is what I think you're primarily interested in knowing. Reallocation review is something that was initiated by Treasury Board last fall when they could see the end of the fiscal year coming and a serious shortage of funding on the horizon. And they asked 24 programs throughout the government to do a base program review and try and identify cost savings or increased revenue or ways to avoid future cost increases. The AG's ministry was given the task of looking at the Ontario Legal Aid Plan and the court system. And very, very quick reviews identifying potential issues were done in the fall, and reports were made to Cabinet. The announcement that the Attorney General made on Tuesday afternoon was the results of the reallocation reviews for the Ministry of the Attorney General. And they're very wide-ranging. There are approximately 20 to 22 different projects cutting across the legal aid and the court system. The short-term initiatives really are based on revenue increases for the government, and the primary one on the court side is an increase in court fees that was implemented on June the 8th. The revenue shortfall on the legal aid side is also a matter of very serious concern, and it's driving several initiatives that are part of reallocation. One of them that was mentioned by the Attorney General is discussions that he's begun to enter into with the Law Society about increased revenue from the legal profession in order to help fund the legal aid plan. And the Ontario government's allocation for legal aid, based on the estimates provided by the legal aid plan for the current fiscal year, is $38 million short. Treasury Board and Cabinet have not allocated sufficient funds to date for what we think it's going to cost to run the legal aid plan. So they've instructed the Ministry of the Attorney General to meet with the profession and look for ways of getting access to greater revenue. No decisions have been made, just very preliminary discussions have been begun by the Attorney General. On the other area that is being driven by this is pilot projects, and traditionally in Ontario, as you're all aware, most legal aid services outside of poverty law services delivered by community legal clinics have been done on the certificate system, with the exception of some duty counsel in the criminal field. There has been interest for several years on the part of the government in looking at alternatives to that, because they keep hearing that in other provinces it's less expensive to deliver legal services or deliver legal aid services by using staff than by using the private bar under certificates. The government's position is that the evidence that it is cheaper is not clear at all. The surveys and the studies that have been done in other provinces have mixed results, and we think to a very large extent aren't relevant in Ontario given the size of the province and the diversity of the population and size of the bar and the legal and legal aid culture in this province. So what is proposed is that pilot projects in several areas would be established in order to evaluate whether or not cost-effective legal services could be provided using staff as compared to the certificate program. The areas are YOA, family law, and refugee law. As well, there will be a pilot project extending criminal duty counsel at some point. The question, as far as we're concerned, is an open one, And I simply want to put to rest any sense that decisions have been made about moving to a staff-based system. They have not been made. The results of the pilot projects, we hope, will give us an indication. We also, because the review was started and finished under such time pressure in the fall, had an inadequate amount of time to consult with the bar and other groups, advocacy groups on behalf of refugees, for example, about these ideas. And it's our intention to involve the bar in the design and the development and the evaluation of the pilot projects. It's not something that the government is interested in doing on its own. I'll let Laurie speak about the status of the refugee pilot projects and or the non-status, because there isn't really much to report on at this point. And after that, I guess we could answer a couple of questions, if there are any.
Is this? Oh, good. There isn't a lot to say at this point, but I can say that, as everyone knows, the Attorney General has announced that we plan to do pilot projects. So I'm going to give you a bit of an update, and it probably won't satisfy you at this time, but if you have further questions, we'll try and answer them. What we do know is that there will probably be a minimum of 2 projects, and that's about all we know. The problem is it's still in its infancy, but that's not necessarily a problem, because what we're looking to do is put together some kind of a working group with the bar and community advocates to structure these refugee offices. And when I say structure, the things that we're going to ask for your involvement or representatives of your group to help us with is to determine things like the location, the scope and the nature of the services to be provided at an office, how the evaluation will be structured, what would be a good staffing of the office based on your experience practicing refugee law, looking at who should govern the actual offices. You know, it will not be a government office. It will, like an in-house government office, but different bodies that could govern it could include the Legal Aid Committee of the Law Society, OLAP in some special form, or clinic funding, and there are probably alternatives that people can come up with. At this point, we're not looking to eliminate the certificate system, and I hope you take that away with you, and that what we're looking to do is an evaluation. In addition to that, we're also aware that we're suggesting or we're looking to set up pilot projects in the face of changing immigration legislation, which may make things a bit awkward. So that will be, in part, some ideas we'll want to know from you about what that may mean, and if there's any sort of ideas we should have, or mechanisms if there's a change in the Act. And that's where we're at, and that's all we know at the moment. And you may have some questions, and we'd be happy to answer them.
Okay, I think it's obvious that everything is pretty much up in the air. So do we have some questions from people? I know it's getting late. People want to leave. But so those of you who want to leave, wait. We all want to leave, but those of you who want to leave quietly, because there may be some people who may want to ask a few questions before we leave. Or if you can hang on for 3 minutes while we ask the questions, then everyone can leave together. No. Does anyone have any questions? Shh.
You said that some questions that are still open. I presume that the question of the $38 million deficit is not an open question. When you talk about increased revenue, you talk about that coming from legal expenses.
I think that the $38 million shortfall is an accurate figure. It reflects the amount by which the difference between what's projected in terms of legal aid costs this year and what has been approved so far by the Ontario government and the other funders of legal aid, the federal government and the others. The Law Foundation and client contributions and so on. There are a variety of other sources of legal aid funds. What we've been faced with in the Ontario government, and I appreciate that it's not the legal profession's fault, but the federal government has been moving out of cost-shared programs on all fronts. And it's particularly it's been particularly apparent in the legal aid area where they've capped and frozen their cost-sharing agreements. And Ontario has added, in the last couple of years, over $100 million in its contributions to legal aid. The federal government has basically kept its cost contributions at the same level. Ontario's proportion is going up significantly. And I think the government's view is that it can't do much more this year, and it has to look to the other funders of the legal aid system, and that includes the bar.
I didn't ask why there was a deficit. I asked you what you're going to do about it. Maybe you're going to look to. All right,
Okay.
Dad, he's looking fast.
All the lawyers.
To the legal profession.
If I understood Mitch correctly on Tuesday, he was saying that they were talking about increasing the levy that we pay along with our
Annual
office
fees.
fees, rather than increasing the statutory deduction that is currently taken on.
I don't think. So there are a variety of ways of increasing revenue, and nothing has been decided. There haven't been any detailed discussions on any of it. What the Attorney General did in his announcement was indicate areas where there appeared to be some potential for additional revenue.
Can I ask another question?
Yeah.
The Attorney General did say on Tuesday that he was interested in getting the refugee clinic up and running by the fall. He may not have meant that as hard and fast date, but that's the date that he gave. I'm wondering if the project director has been designated that.
Oh, project director. Yeah, I think that he's keen, and everyone is keen to get these pilot projects operational. I'm not sure that he meant that we would have on September the 21st an operating project. That seems optimistic to me, and I'm not sure that he meant to say that, although I heard that as well. In terms of developing the pilot projects, the ministry's representative is Laurie Newton, who's I think will shortly be in touch with the profession about getting representatives to work on the development of the pilot projects and on a consultation process about, I guess, identifying issues. She's given an indication of some of the issues that need to be discussed in this. Well, there are probably a lot more. We need to begin thinking about this. So very shortly, we'll be in touch with the profession about beginning to work on this.
Okay, I think if you would have come earlier in the day, you probably would have been peppered with more questions, but I think we're all exhausted, but I'm glad you came anyway. Thank you. Yeah, it was too long of a day, but I mean, at least you got to say what you wanted to say.
Yeah, no, it was useful, and I'm glad we had a chance to touch on it. That was good. Thanks for that. It wasn't nearly as bad as you said it.
I know, I'm just...
You're such a tease.